A very good evening to you, ladies and gentlemen. I am happy to welcome you to the 12th webinar of Series 6 on Basic of Law titled Interim Injunctions. This is the 41st BSL webinar for the years 2025-2026. This webinar series is organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the chairman of the Webinars and Legal Symposiums Committee and the president of BSL, Mr. Rajiv Amarasuriya, the co-chairman, Mr. Chature Galhena, Secretary of BSL, and Mr. Pasindu Silva, Treasurer of BSL, and the conveners, co-conveners, and the members of the Webinars and Legal Symposiums Committee. I would also like to extend my heartfelt gratitude to the Executive Committee of BSL for all the support and guidance. For today's webinar of Interim Injunctions, we have with us an esteemed panelist, Mr. Faisal Mustafa, President's Counsel. Having completed his primary and secondary education at Royal College, Colombo, Mr. Mustafa entered the Sri Lanka Law College in 1990 and was admitted to the bar as an attorney at law in 1993 and is completing 30 years in practice. He successfully read for a master's degree in commercial law at the University of Aberdeen in 1995. Mr. Mustafa was appointed as the President's Counsel in 2012 and has a diverse legal practice ranging from original courts to the apex court, specializing in commercial law, commercial arbitration, intellectual property, fundamental rights, administrative and constitutional law. He has also served as a Cabinet Minister of Local Government and Sports, State Minister of Aviation, Deputy Minister of Investment Promotion, and has held several portfolios as a Member of Parliament from 2004 to 2020. I warmly welcome Mr. Faisal Mustafa, President's Counsel, for today's session. To moderate today's session, we have with us Mr. Pulasthi Rupasinghe. Mr. Rupasinghe is an independent legal practitioner who was called to the bar in 2011 and has started his professional career as an associate at Julius and Creasy Attorneys at Law, specializing in areas of corporate restructuring and mergers and acquisitions. Thereafter, he worked as a junior counsel in the chambers of Mr. Faisal Mustafa, President's Counsel. Currently, he is operating his own chamber, specializing in corporate litigation, arbitration, and administrative law. He also functions as a legal counsel at Nilakanthan and Nilakanthan Attorneys at Law. Mr. Rupasinghe has previously functioned as an advisor to the Ministry of Local Government and the Ministry of Sports. He holds Bachelor of Laws and Master of Laws degrees from the Faculty of Law, University of Colombo. I also warmly welcome Mr. Pulasthi Rupasinghe, Attorney at Law, for today's session. And without any further ado, I invite him to commence today's proceedings. Over to you.
Yes, thank you, Isuri, for that introduction. Good evening, everyone who is joining us on Zoom as well as on YouTube live. Today, we are discussing a very fascinating area of the law with one of the most eminent practitioners in Halsdorf, as well as, of course, a well-known public figure, Mr. Faisal Mustafa, President's Counsel. The area that we are discussing today is the basic elements regarding the law relating to injunctions, which I think Mr. Mustafa is an eminent expert on this area. Those of you who practice in Colombo would have seen him regularly in courts involved in cases where injunctions are in issue. So without taking much time by way of an introduction, we will straight away get into the discussion. But before that, I would like to outline how we plan to do this discussion today. We will broadly discuss the area of injunctions from the perspective of the plaintiff, that is the person seeking an injunction from court. And thereafter, we will move on to the material particulars that one must be mindful of when drafting pleadings with regard to injunctions. And then we will also focus our discussion with regard to injunctions from the perspective of the defendant or the party before court who is seeking a refusal of an injunction or the setting aside of an injunctive order. So we are planning to focus this discussion from a very practical perspective, from a practitioner's perspective. So and also we would like we are planning to engage in this discussion in a manner which is useful particularly for junior practitioners who are just entering into the practice and are maybe not particularly familiar or well versed in this area of the law. So, sir, I would like to pose the question to you. It's a very, just to lay the groundwork for our discussion. If a client comes to you uh, and wants some sort of relief expeditiously, under what circumstances can we move court for an injunctive relief? That is my first question to you.
Yeah, first question is vis-a-vis a normal plaint, on what instances can you get an injunction if a client comes to you? So primarily, when a client comes to you, normally you wait until the end of the trial to get the fruits of victory. Here, client comes to you and tells you, I can't wait until the conclusion of the case. I need some speedy relief to prevent irreparable damage. So therefore, when it should, a plane should have the requisites of the plane. In addition, you need to stop something from occurring or a continuous damage. So that's the basic distinction. So there's a greater responsibility cast upon you as a counsel to see whether you can sustain an injunction, because you have to first be able to sustain the substantive relief, and in addition you have to see the basic requirements whether you can obtain an enjoining order or an interim injunction. The first requirement is whether you have a prima facie case. That is whether there's a reasonable probability of winning the case. That is normally you file a plaint, but here it's a full evidence plaint. That is, you will, when you stand up, you'll have to tell the judge, look, I have a case. If I don't get this relief, I would suffer, but there's a reasonable probability of winning the case. If you can establish that you have a prima facie case, then the balance of convenience. What do you mean by balance of convenience? That greater damage would be caused to you than to the defendant if relief is not granted. So if you can, they are all very interconnected. The irreparable loss. Irreparable loss would mean irreparable damage. Earlier, there is a school of thought, and also there is case law. So if you can get damages, you're not. But now, irreparable damage would be not to allow anybody to take fruits from their wrongful action. So therefore, when you draft a plaint, you have to plead that you would suffer irreparable damage unless you get injunctive relief.
I just to highlight 2 points that you mentioned in this in your introduction. One is, now there is the common consensus or the common view, if I may say so, is that where damages are a remedy, or is deemed to be an adequate remedy, injunctive relief is not available. But you seem to suggest that under certain circumstances, the wrongdoer can be prevented from benefiting from his wrongdoing. Can you just explain to the viewers what you mean by that?
So if you look at 217G, you can get a permanent injunction. Therefore, you can get an enjoining order and interim injunction. Secondly, the earlier case law was that if you can quantify damages. Today, anything can be quantified, that you're not entitled to damages. But today, a simple example is, courts have continuous held so, if you give a premises on lease and you file a ejectment suit, it will take 5 to 10 years for the suit to be completed. So court has held a person should not be able to take benefit of his wrongful actions. That wrongdoer principle. Therefore, if you can go to court, not only in any case, if you can prima facie establish that this person is a wrongdoer, he is taking benefit from his wrongful act, and day to day, if he continues the wrongful act, even though you won't be able to get the substantive relief is distant, you should prevent him from taking benefit from the wrongful act. So my belief is now, don't stick to whether damages can be quantified. If you can establish ex facie that the defendant is a wrongdoer, and every day, if he continues to be allowed to do that he will take fruits of his wrongful action, then you can get injunctive relief.
Thank you, sir. Just another thing that I have seen sometimes in court. I think I have seen you actually stating this very vehemently in court, that in certain instances injunctive relief must be granted to maintain the status quo. What do you mean by that, and what is the can you expound on that
Supposing
that
there is
principle?
a threat of a particular action being committed, that somebody is trying to do something, or say wall, somebody is trying to break a wall and encroach. Before that person is allowed to do so, you go and get an enjoining order until you get the substantive relief to maintain the status quo. I mean, basically a change in the in status quo in anything. In any, supposing somebody is trying the present status quo, you go to court and say, sir, is this? If the defendant is allowed to do it, he will change the status quo. And if he changes the status quo, my substantive relief would be affected.
Thank you, sir. Just and also now you highlighted another thing in your introduction, that is the remedy available as a permanent injunction. Now, sometimes it is claimed that the final relief and the interim relief can't be the same, or there must be some distinction. What is your view? Is it applicable across the board, or in certain
No,
instances can you ask for a final relief that is similar to the injunction? Sorry, can you ask for a injunctive relief that is in certain instances similar to the final relief?
the plain reading of the law is if you can get a permanent injunction, you can get an enjoining order and an interim injunction. But court has been hesitant. How can I give the substantive relief by way of interim relief? However, in terms of the law, it can be done. And also, in that instance, you have to show the degree of establishing your case is great. That means it's a prime. You have to a reasonable probability of winning the case should be of a very high degree, like the shell gas case where
That is,
plaintiff,
that is Shell Gas versus, I believe, Shell Gas versus Samyak Lanka in 2005 3SLR. This is
that's right,
reported
where
case.
the plaintiff had certain equipment in the defender's premises, and that there was a threat of the defendant taking it away. So court gave the enjoining order and interim injunction, which was also the substantive relief. So therefore, I think we should move from that norm. Globally also had moved that the substantive relief and interim relief cannot be one and the same, is a misnomer in my belief. But court has been hesitant because continuously arguments have been placed that the interim relief and the substantive relief should not be one and the same. But if you look at pleadings, if you are entitled to a permanent injunction, by you're also entitled to enjoining order and the interim injunction in the like manner. And now I think court has taken moved towards that direction.
Thank you. Just to outline the just by way of further information with regard to what Mr. Mustafa just expounded upon, particularly for the benefit of the junior members, I think if you can consider those who have joined us, these leading some of the leading cases in this regard, that is Felix Das Bandaranaike versus State Film Corporation in 1981 to SLR, then Karyavasam versus Sujata Janaki in 2013 1 SLR. And also, I think, sir, you would also, I'm subject to any clarification by you, the case of Seelavati Mallava versus Kirtirath, 1982 1 SLR. I think those precedents or those case law would highlight, I think, the principles that you just explained to us, if I
think
may say so.
Felix Das Bandaranaike's case set out the basic principles of injunctive relief. That you need to establish a prima facie case, there has to be balance of convenience and irreparable loss. In addition, it clearly stated that injunctions are decided by affidavits. So you have to be very clear that you state your case in full. Now there's also a debate whether count affidavit can be filed. Now, you see, you file a
Sir,
plain.
just to interrupt you, I think we will come to that shortly.
Later.
I just wanted,
Okay.
because
So then
I think
about
we
the
need to discuss at length about pleadings. I'm just
okay. So
I am about to come to that.
then the case law which you Silvati Mallavan and the other case which you mentioned, right, dealt with the wrongdoer principle. What is the wrongdoer principle? That Those cases all will be Jekman suits. But that principle applies across the board in any case. If you see the dicta of that case, what court continuously held was a person who is a wrongdoer should not be entitled to benefit by his wrongful act. So basically, when you draft pleadings, if you can establish to court that I can get the substantive relief, which is distinct from what I'm asking, but any benefit by that person, like you continuing to do, would affect you in any form. Now, if you take ejectment suits, you see them once. If it's a business premises, if you're restrained from carrying on a business, there is no point in you being there. So therefore, the wrong will vacates the premises. I mean, coach looks at it from that perspective, because he's in occupation, but he can't take benefit of his wrongful act. So basically, those are the principles which are set out in those case laws.
Thank you, sir. Now we come to the next part that I think I have seen you drilling this down to juniors all the time. The pleadings. How should we structure the pleading, that is the plaint in most instances, when seeking an enjoining order and interim injunction, injunctive relief? What are the material particulars and what are the things that the counsel should be mindful of when he or she is drafting a plaint seeking an injunction? What are the main things that we have to be mindful of?
The basic distinction between ordinary plaint and a plaint for an injunction is you plead evidence. When you draft a plaint in a normal trial, you don't plead evidence. Here, you swear an affidavit, and your case depends on how strong your affidavit is to support the averments of the plaint. Because you're going to court and presenting evidence in a form of affidavit and telling court, look, this is my case, and you have to, in addition to the requisites of the plaint, you have to disclose everything to court, because I will deal with that later on, suppression and with misrepresentation. And you have to substantiate to court that irreparable, you have to plead a distinct averment that irreparable loss and damage will be caused to you. So then, in addition to the requisites of the plaint, you have to establish a prima facie case through your plaint, and then you have to say that greater damage would be caused to you, that is balance of convenience is in your favor, and irreparable loss, in addition to the material which you place to substantiate that position, you have to plead that unless you irreparable loss, you have to plead that irreparable loss would be caused to you, and the judgment would be rendered nugatory unless the interim relief is given. So that averment in the plaint is also important. Just pleading that averment alone would not suffice. You have to plead circumstances to establish. And in addition, when you draft a plaint in an injunction matter, there can be affidavits annexed to your affidavit, because you have to substantiate your position. Sometimes there are matters within your knowledge, you plead that, and there are affidavits which you get from third parties, which is part of your affidavit, and you have to plead so that you can satisfy court that you have pleaded everything before court. And one advice I would give juniors is, your credibility matters when you draft an injunction. That is, however good you are, when you stand before court and you don't have credibility and you have a reputation that you misrepresent or suppress facts, you will never get an injunction, because it's a contract between you. It is a client, but it's actually you who has a contract, the counsel. There's a greater responsibility cast upon you, even though your file affidavits are drafted by you, pleadings are drafted by you. Most often, the clients do what you tell them to. So basically, it's a greater responsibility on you. And if you suppress or misrepresent facts, it might be difficult to put it on your client sometimes, because the court expects you to put most, unless they have suppressed it purposely, matters with utmost honesty. I have to give credit to my senior, Mr. Parthalange. Always he has told me that if there is correspondence or there is any form, if there is a document against it, plead it, but state your perspective, because when on the notice returnable date, the easiest for the other side to do, irrespective of marriage, to come to court and say he has misled court and obtained the enjoining order because he has not produced this document. So I'm advising juniors, however bad documents are, you tell court, look, I believe that this document might be against me, but looking at it from this perspective, I can substantiate my case. So please take my advice. If you want to have the trust and confidence of court in getting ex parte, because only the civil procedure code gives you the right to get ex parte relief. That's as of right. So court will hear you ex parte. But if you go to the court of appeal and file a writ, or if you file a FR, you can, by as of right, you can't get ex parte order. But here you can get interim relief ex parte in terms of the statute. Therefore, there's a greater responsibility cast upon you. And I would also like to tell you, don't think this is the only case. And this is not, you're here to play a test match and not a limited over innings. So therefore, don't mislead court, because if you mislead court, you might succeed with one court, but the judge or that court will never give you any relief hereafter.
So basically, the pleadings that we submit to court in the first instance must have a good chance of sustaining inter partes and extended inquiry. I think that.
Yeah, basically, you have to be conscious of the fact that on the 14th day, the other side would come to court and tear you apart if you have lied to court. And also, you have to be confident that you can substantiate your interim injunction. There is no point getting an enjoining order, and after that, on the 14th day, because on the 14th day it can be set aside on your own pleadings. So, what Pulasti, one has to be conscious of is, it is not the short haul. You have to succeed at an inter parte interim injunction inquiry if you're going to succeed in interim relief.
Just one more question before we go on to the defendant's perspective. Now, this requirement to submit all available material, just to expound on it. So, what does it mean that unlike in a regular plane, you have to flesh out your whole case? Basically, you might even have to bring in all the evidence that you propose to submit at the trial at this stage itself.
Your substantive relief, it's beyond getting substantive relief ex parte, right? You have to be conscious of the fact that you have to plead evidence in totality, right, to convince the judge that you're entitled to your substantive relief, and also the other issues with balance of convenience and irreparable loss. So I would say you stand or fall in your affidavit. So you have to be very conscious. It's totally distinct from a regular plane. At law college, we learn you don't plead evidence in a normal plane, but in a injunction, it's a full evidence plane.
Thank you, sir. Okay, now we come, I think, to the favorite your favorite area when it comes to the law relating to injunction. That is, how do we approach an injunction inquiry or enjoining order inquiry from the perspective of the defendant? Now, firstly, I think you just highlighted that in your introduction. Now, in terms of section 664, you can get an ex parte enjoining order, which is for 14 days, which then can be extended periodically until the conclusion of the the interim injunction inquiry, as and when required by court. But I think you highlighted one important matter when you were talking about the plaintiff's perspective. That is that the technically we can oppose the extension of an enjoining order under certain circumstances. So before we go into the interim injunction inquiry, I think I would like to discuss with you on what are the basis or what are the mechanisms by which one can object to the extension of the enjoining order, either by filing papers or on the notice returnable date itself, on the pleadings of the plaintiff himself. How can we oppose, or how can we get an ex parte enjoining order set aside?
There are two
I
in
think
the
this is your favorite
CPC.
area. I know this for a fact. Yes.
Now, you're the defendant. Firstly, if you wait until the summons returnable date or the notice returnable date or the date on which the 14 days of the enjoining order, the plaintiff has already won his case because summons returnable date says on the 20th or the enjoining order is to be extended on the 20th. They are seeking to stop a meeting which is on the 16th or 17th. What do? Client comes to you and says, sir, they have got this. When you look at the notice returnable, it says 20th. The CPC provides for that. Then firstly you see whether there is suppression or misrepresentation. The law is very clear. Alfonso Apami versus Hettiarachi, Walk and Sons, I'll come to that later. You have a contract with court when you get an ex parte order. So therefore, if you breach the principles of uberrima fide, court will not go into your merits. So if you feel that there's a blatant suppression and misrepresentation of material facts alone, and you don't need to substantiate anything else, then you can come under 6643. Therefore, you file a petition and say, there is suppression and misrepresentation. Therefore, you ask court to suspend the enjoining order. But that also can be done inter partes. So what you have to do is, you don't wait until the notice returnable date. You file a petition, you serve papers on the other side, and then you tell court, sir, I can't wait until the notice returnable date because the whole purpose would be lost. The plaintiff would have achieved his purpose. And at that point of court will take you serious because court is also conscious that you can't wait until the notice returnable date. So I would advise a counsel, if the client is willing, it's a tedious job because injunctive relief, as you know, Pulasti, you work overnight, this branch of the law, as it is lucrative, it is a lot of hard work because it needs you to work overnight. So you draft papers overnight, you go to court, file a petition, stand before the judge and say, look, I can't wait until the notice returnable date. There is suppression, blatant suppression and misrepresentation. They have misled court. Therefore, please suspend this enjoining order. So then, on that basis, you can get, that is, before the notice returnable date, you can come under 6643.
Yes, thank you, sir. Now, that is one aspect. Now, you highlighted the provision there in section 664, 664 3 of the Civil Procedure Code, where you can move court to set aside an ex parte enjoining order on the basis of suppression. Now, what if there are other grounds that are available to a defendant to get an enjoining order set aside? Now, 6643 application, as you said, must be made by petition and affidavit. Now, what if there are other grounds also that a defendant can urge before court to get an enjoining order set aside? Then what is the remedy available to a defendant?
It's always better to go under 666. You can come before the summons returnable or after under 666. If you look at the Civil Procedure Code, 6643 is very limited only on suppression and misrepresentation. But 666 is wide ambit. You can not only move to set aside the enjoining order, you can attack an interim injunction as well. So therefore, you can come under 6. Now, supposing it's barred by a positive rule of law, if there are other circumstances, it gives you wider scope because I have seen courts cases where they have come under 6643 and courts taking the easy way out saying that there is no suppression and misrepresentation. I'll look at it at the end of the inquiry. Right? But if you come under section 6, you have a wider playing field. And you can go to court, bring in other circumstances, like in an interim injunction inquiry, place everything before court, and come to court and say he was not entitled to the injunction, and then move to get it suspended.
So basically, if you go either under section 6643 or 666, it will be an inter partes inquiry where you file a petition and affidavit seeking to set aside the adjoining order, and the defendant would be permitted to respond to that, and then there will be an inquiry.
It is inter partes to this extent. You can also, that depends on the discretion of the judge. In the plain, there is an obligation to state your case in full. If you're not entitled to file certain courts takes the view that you're not entitled to file a counter affidavit to the interim injunction objections, you can tell the court they cannot place any material. They're only entitled to be heard. If I file this petition, because they are not entitled to place any material once you're supposed to disclose all your material in the plain. But that would depend on how the judge looks at it. But you have to serve papers before you come and support your application.
Okay. Sir, just to now, there is another the matter that you highlighted. That is you can come before court on the summons returnable date, as you said before, and object to the extension of the enjoining order. Now, my understanding is that you can do so without placing any material before court, but on the on the strength of the material, sorry, based on the material filed by the plaintiff himself. Now, can you explain how do you object to the extension of the enjoining order without filing any material, but based on the material, if any, that is filed by the plaintiff?
If you take section 6642, the enjoining order has been moved to be extended on the notice returnable date or the date. So the plaintiff would move, say, to extend. So the same right is given to the defendant because you have to have good and sufficient reason to extend the enjoining order. This gives you the defendant the right to come to court and say, on the plaintiff could not have obtained the enjoining order. Therefore, either you can say there is no prima facie case, there is no balance of convenience, there is no irreparable loss. In addition, there is a breach of uberrima fide or utmost good faith. So, generally, courts say, why don't you wait until the interim injunction inquiry? I will expedite it. Then you have to have a consultation with your client and say, shall we wait until the interim injunction? Then, if you then the best advice is on the notice returnable date to file your objections, where interim injunction inquiries are decided by written submissions. And you tell court on that date, okay, we don't need a formal inquiry. Can we dispose it by way of written submission? Because the formal inquiry is just fixed for the sake of disposing by written submissions or making oral submissions. So if you can tell court, that is court craft. You tell court, Your Honor, I've been instructed to object to the extension, but I'm filing objections to the interim injunction. If parties are agreeable to expedite the interim injunction inquiry, then we can determine this by written submissions and expedite the whole matter. That will all depend on what your client wants. Because judges can't refuse you to make submissions objecting to the extension of the. But we know the burden of the judges who hear cases, they don't want to duplicate. Also, there is another risk which you are not placing any material to court. Supposing court extends the enjoining order, a judge can take the view that I have made this order, I must defend this order. So sometimes it might be better than getting an adverse order to agree to extend the enjoining order by consent until the interim injunction inquiry is concluded and thereby expedite the interim injunction inquiry.
Okay, so basically, you have technically a defendant has a right to object to the extension of the enjoining order purely based on the material uh, placed by the defendant, or if there is some material omission that is apparent from the plaintiff's own pleadings. But your advice is to always, no, not always, but your advice is to generally place the defendant's version of events and the material available to the defendant also before the judge and expedite the interim injunction inquiry. Am I
As you know, Pulasti,
correct?
you also done many injunction, you've done many injunction, me as well, right? Yeah. We have to look at things from the client's perspective. If you get an adverse order when the enjoining order extended, right? The psyche could affect the case. This is what I say. So why take an adverse order without placing material before court? I mean, that is advocacy, and that is how you have to take decisions based on. If your client tells you, sir, give it a try, right? You have to tell him the pros and cons. Here we are without placing material because there's an affidavit only on the plaintiff. So court will not divert from that affidavit. But if there is inconsistency in the affidavit or the material placed, or if you can establish that the material doesn't substantiate the relief without placing any material, there's a risk. So if the client is willing to take that risk, yes, because end of the day there's an affidavit on oath affirming this certain fact, right? Then you are without placing any material or any affidavit saying that what is placed in this affidavit and the documents is bad in law or is false. So the burden is great because you are not placing material. So you have to be very conscious of that fact. And these are decisions which you have to take sometimes on your feet, sometimes with the instructions of your client.
Sir, then then coming back to the statement of objections which we are entitled to file in respect to the interim injunction inquiry? What are the particulars that one must be mindful of when drafting the objections? Because
I
I believe the objections, statement of objections you file in interim injunction inquiries drastically different from from an answer, because in answer you sometimes try to merely state a bare denial, but I believe the statement of objection must be a bit more fleshed out. What is your view about it?
Yeah, basically if there's a positive rule law, if legal is not sustainable, you place the law. But I would advise anybody to take uberima feed as the best way out, because the law is very
That is
clear.
utmost good faith.
At most, I will not hear you on the merits if you have breached your contract with court. So that's I firstly, when I draft objections, I first look at that aspect, because then even if there are merits or demerits in my objections, when court looks at that position and court is satisfied that there is a breach of uberima fide, court will not consider the merits and demerits, and you give court also an easy way out. And then you place your case and you say that there is no prima facie case, balance of convenience is in your favor, irreparable loss, and then you take up the position it can be quantified, damages can be quantified. If you are the defendant, right, you take up that position. It is left to the judge to decide. If you sometimes you have a very very bad case, right, well, because judges take diverse views too. I mean, we are counsel, we place material, and if we have to take up the position, the law has certain case law has held that if you quantify damage you cannot get relief, then you, if you offer the defendant, one of the positions you can take is damages can be quantified.
So basically, sir, am I right in saying that just as when we discussed about the plane,
Yeah.
we must place all evidence that is before us to court to justify the refusal of an interim injunction? So it is just like as we discussed in the plane, we have to submit all the evidence that is available to us and
It's
together with
also
an
an oath.
affidavit.
It's also an oath, and then you have to place and collect documents as much as possible. And if the plaintiff has only placed his affidavit, and if you can get affidavit to corroborate your position, your case is strong. You come to court and say, look, the plaintiff has only sworn to his affidavit. I have other affidavits so I mean, you have corroborated your position while the plaintiff has not. Or you have if the plaintiff has not placed some material, and if you have material to prove the contra by way of material or advice, I mean, take time when you draft objections, try to collect affidavit documents. Sometimes it might even require that you take a short date. You don't have to wait for 14 days. If you need to get additional documents, when the enjoining, you ask that this enjoining order may be extended by only 7 days. I only need another additional 7 days to get material. But you have to give a lot of thought in drafting your objections, because like a plane could, then there will be no fall on the plane. Your objections, if you can't substantiate that the plaintiff cannot maintain its position, right, then the interim injunction or the would be issued. And if the interim injunction is issued, that relief will operate until the end of the trial, right? So as you know, trial will take 2, 3, 4 years, right? So if during that period you would have suffered enough. So I mean,
Yes.
end of the day, you have to be very conscious of that fact.
Thank you, sir. Just a message to the participants who are joining us. There is a Q&A box in your Zoom links. You can post any questions to the Q&A box. In fact, I have received several WhatsApp messages posing several questions, but I think we would prefer if you can post any questions to the Q&A box that is there in your Zoom links. And sir, just to add one more thing that that interests me, particularly in drafting objections, there is I have seen in certain instances in injunction inquiries, uh, the defendant's counsel focuses on the facts and not on the law. But I believe, from what you said, that in fact legal objections or objections with regard to the maintainability of the action, or which cast certain doubt, a legal objection which would cast a doubt on on the strength of the plaintiff's case, should be at the forefront of your statement of objections. Am I correct in saying that?
You're perfectly correct. It should be even in a 666 application, even in a 6643 application, the legal position that is not maintainable in terms of the law, even though it's a suppression or misrepresentation, it can be brought within that. So the legal, you're right. I mean, not only the questions of fact, the law, you can place it, the contra and say in terms of the law is not entitled to it. And that is very important. But that will short circuit the whole thing. If you can substantiate that in terms of our law that the injunctive relief cannot be obtained, right? I mean, that's the easy route, because questions of fact, there are two sides to it.
Thank you, sir. Now my understanding is, or my experience in court is, that normally the interim injunction inquiry is disposed by way of written submissions. So, any pointers that you would like to give, particular to the junior practitioners, from both perspectives, from the plaintiff's perspective as well as the defendant's perspective, what you should be mindful of when you are drafting written submissions?
Pulasti, I would like to start with pleadings first, right? As you know, our pleadings are it has to be concise. Written judges, especially original court judges, have a higher workload than appellate judges. Therefore, it has to be, I would advise to have a synopsis and be very concise. That is, and basically, don't continuously repeating the same thing. So I would say restrict it to a couple of pages. Be very focused. Where judges want us basically a synopsis or a very concise statement would do, because otherwise judges won't read it. I mean, if you have 20, 30, 40 pages, right? Nobody will bother to read it. And also pleadings also, as much as you have to plead questions of fact, either in your plaint or your objections. I have seen judges cursing when pleadings are long. You know that. I mean, judges also would prefer very concise pleadings. And unfortunately, there are certain occasions where pleadings are very long. And it's a repetition of the same thing. So if you want to be successful, right? Simple English, a concise statement would suffice. There is no point in jargonized things. There is no point in using big words. There is no point, because judges are not interested. I mean, state your matter very briefly in simple English. I mean, that is what and also that's only what I know.
Is there any advantage in moving for oral submissions in interim injunction inquiry, or what is your view about that?
Yeah, I mean, end of the day, there are two. I mean, you make oral submissions. It will be advisable, if you get opportunity of making, you also get permission to file written submissions as well. Sometimes orders are written 2-3 months after oral submissions are made. But if you have it in your written submissions, even in an appellate forum, it will be very clear that you have taken up this position. So I would say, from a counsel's point of view, making oral submissions is good. You can engage the judge and see his mindset and make submissions accordingly. But sometimes, sometimes judges change, right? There was a case where I made oral submissions and written submissions. Then the judge changed. Judge was transferred. We moved to file, make oral submissions again. But the judge was, I said, I will make an order on the written submissions. So also be mindful that you can expedite matters if you do it by way of written submission. I was for a defendant in a case, and the plaintiff's counsel was continuously making submissions for 6-7 days so that he could prolong his interim relief. So after the plaintiff finished his case, I said, I'll be happy to make high-five written submissions, and my learned friend also could answer by way of written submissions if he want to, because I knew that the interim relief will drag for another 3-4 months if you are going to accommodate dates for my submissions and also for his counter submission. So it all depends on how if there's a judge who just gives a half an hour and concludes in a day. But if there is a judge who allows the counsel to make 3-4 hour submission, then fixes another date for the other counsel, so it's all advocacy. How soon can you conclude the inquiry? So that's a judgment call you should make. So end of the day, written submissions, it's on record, right? But oral submission is actual advocacy. So you have to balance the two. But if you get an opportunity of doing both, that's the best.
Okay, sir, I think we have covered covered the ground as to the main aspects with regard to injunctive relief. Anything else that you wish to add before I move into the next part of our discussion?
Yeah, I do again contempt.
Yes, I think we will come into the contempt issue, but any other
I think
aspect that you wish to highlight that I may have missed in my.
I think we've covered most of it, but I think basically the plaintiff's perspective, the defendant's perspective, the enjoining order, how to set aside the enjoining order, the interim injunction inquiry. Another area is the right to file a counter affidavit, which might interest some of
Yes.
the juniors.
Yes. Now I have seen in certain district courts that is permitted, but I believe it is not something that is that you can ask as of right. What is your view about that?
There was a judgment I once cited of Justice Vimala Chandras where he says a counter affidavit. But looking at it from a logical point of view, the plaintiff states his case. The defendant states his objections where the absolute falsehood which is stated. Then you go to court and say, I am not placing any new material, but I have to be given a right to counter it. And the justification is in the Court of Appeal and the Supreme Court, they file a plaint, they file limited objections, and they found a counter. And I go on the basis what is not prohibited is permissible. So I feel that you can make an application not to cover your deficiencies in your plaint, but the defendant has stated certain falsehood which you are entitled to contradict, and it would help you if. And there are many a times I have filed counter affidavit. I make that application, and sometimes courts say no, but I tell court then it is not to cover any lapses in my plaint. The defendant has filed objections. There are certain matters which I have to place to counter because there is deliberate falsehood which has been pleaded, and without that, I cannot have a proper interim injunction inquiry. So I would advise juniors, right? Always, if you feel that you need to counter matters in the objections, please move to file a counter affidavit and then argue that you are entitled to do so.
So from looking at it from a defendant's perspective, that means we can always object to the filing of a counter affidavit on the basis that the plaintiff is trying to cover his lapses
But
by
also,
trying to adduce new material.
yeah, but also if now courts have taken a view that when you file a 6643 petition or 666, that they should be given a right to file objections.
Correct.
So if that same right is given, I think you're entitled to file a counter. You can argue that. Yeah,
Correct.
so
Yes.
you have to always look at the judge's perspective, whether the judge is willing to accommodate, because it's a gray area. There is no court of appeal judgment on this, or whether recently we got leave in a case, but then sorry, we in the civil appellate of in
High Court
Colombo.
of Colombo,
I
yes,
got an
right.
order. I got we got an order. In the Supreme Court, somebody canvassed it saying that there was no right, and that was refused. So in fact, court said that you have a right to file a counter affidavit, but there is no finality in that because only leave was refused.
Okay. Thank you, sir. Then we move into the next. I think before we go into the Q&A segment, the final part of our discussion, I believe, that is now once you get interim relief, how do you compel somebody to uh, abide by that interim relief? And also, I want to discuss that with you. That is from the plaintiff's perspective, but also from the defendant's perspective, this cardinal rule that we have, which we colloquially call comply and complain. What how do we enforce an interim relief, and how should the defendant, how should a counsel advise a defendant when an interim relief has been granted against him, and with regard to compliance? Can you explain to us?
I think, firstly, we are officers of court. When an enjoining order is obtained, if a client is trying to evade taking summons while being conscious of the fact that an enjoining order has been served, will be party to something we should not do by asking him not to accept it. Because if he has noticed it in some form, he's obliged to comply. Now court has taken, now you can serve it by WhatsApp and by telephone. So firstly, if a client comes to you, comply and complain. Because in terms of the law, you are liable to be punished for contempt, and also you're liable to be imprisoned if you do not abide by the order. Because there is no point in court issuing orders if one doesn't comply. Now today, in addition, there is the Contempt Act, right? So you can I of course say that it should be filed in the district court because it was, but you have also the right always to go before the Court of Appeal in terms of Article 105 to go and file contempt. So basic principle is an enjoining order or an interim injunction has to be complied. You can sometimes you want to argue it's vague, it's prolix, and therefore you will not. It's very dangerous to do so. Especially, client can later on turn and say, my lawyer told me not to comply. There are instances where it has happened to counsel. So be very conscious of the fact. Clients will come and go. You're an officer of court. Firstly, tell your client, if you do not comply, you can go to jail or you'll be dealt with comply. And also, if you're the plaintiff, you ask for agents, servants, and all those acting on it, cover everybody. And in addition, there are cases which said, even if now today we say controversial cases, it's in the newspaper before it was served. So even if you have not received papers, you're obliged to comply. So basically, compliance is mandatory, and also that you come then you file papers to vacate it. Otherwise, contempt proceedings are very serious. And if you are liable for if I am a counsel for the plaintiff and there is a violation, what I will do is I'll tell court, postpone the interim injunction and enjoining order matter until the contempt proceedings are concluded, and court will give contempt proceedings precedent. And therefore, if the contempt inquiry goes for about 2-3 months, you will be stuck there for some time. And court also, if the plaintiff comes and establish that there has been contempt and gets summons, court will not look at that person leniently, and also will punish you by keeping the enjoining order in operation until it is concluded. I don't know whether you agree with me, Pulasti, on that.
Correct. There are several matters that I want to dissect in what you
Okay.
explained.
Okay.
Firstly, you raised an interesting point. Of course, now with the recent amendments to the Civil Procedure Code, particularly Section 66, so on and so forth, you can serve summons not only through the fiscal but through courier, WhatsApp, and various other means. And also, that is very important. So I think the junior practitioners sometimes are still not mindful of that provisions in the CPC, where now you are given the opportunity of, in fact, serving summons by various other modes of service, including registered post, courier, so on and so forth. And also, I think in the good old days, I have seen you and certain other councils moving for a special fiscal to serve summons, but that is also now permissible in terms of the CPC itself, where you can ask the fiscal of that particular district court to even serve summons outside jurisdiction of that district court. And also, another matter that you highlighted there, that is, in a contempt proceedings, even if the defendant evades summons, can you urge court that there is contempt because there is material to show that the defendant is aware of the enjoining order? Can you explain that a bit
Yeah,
more?
basically, plus you have seen many a time we move court that to inform the defendant by telephone at our expense. So all what you have to do is to show that the defendant was aware that this order was given. So just because summons was not served, that's not a ground anymore. We have many a time when we get the enjoining order, we now courts are technology have improved, and courts also have become more proactive. During earlier times, it was a good way where their lawyers said, don't accept summons, therefore you won't be liable for contempt. Now, all what we have to do is to show that we paid the registrar register office at our expense. It was communicated by telephone. Then the question of formal service is not a fundamental defense anymore. So all what you do is to show that you are aware. And many a time today, when an enjoining order is obtained, courts permit you to communicate by telephone or WhatsApp or fax. So question is, evasion today is tough, and in the day and age of technology, it's tough. And also, if it's a controversial case, it's in the newspapers as well. So
Yes,
long as you show
because
that,
yes, I have seen you supporting an application before a district court many years ago, where you demonstrated to court that the defendant had indicated that to a newspaper that he is unaware of the case, which means he is technically aware of the case.
yeah. I mean, I'm obvious. I mean, that is. I mean, as juniors, don't ever advise your client if he has some form of notice to take up the position that you're not aware, because clients will let you down at some point and your credibility is at stake. If a judge feels that you were a party for not complying to an order in any form, right? Especially if you come to court and tell court my client was unaware was enjoining order was issued, right? When there is some material or if the plaintiff can substantiate some form, your credibility in court is more important long term. Especially if you take seniors in Halstoff, they have succeeded not only with their brilliance or not with only their hard work. The fact that when they stand up and say something in court is willing to accept what they say. That is the most important thing in achieving this profession.
Another thing that I wanted to just emphasize is that you spoke about the contempt inquiry. Now you move for contempt, you file papers saying that the defendant is guilty of contempt, and the court issues summons. And what you seem to suggest was that you can urge court to conduct the contempt inquiry parallel to the interim injunction inquiry, or even parallel to the trial. Or sometimes, if you can convince court that there is a serious act of contempt, maybe you might be able to prolong the interim injunction inquiry, because court might be inclined to take up the contempt matter first.
If you are a counsel for the plaintiff and you can demonstrate in some form that there was evasion of accepting summons or he was fully aware, and you can convince court, right, that this is a person who has no disrespect to court, because contempt is contempt of court irrespective of the facts. So court will take cognizance, and anyway court is obliged to give a contempt inquiry priority above any other matter. That is the norm. So you can use that to postpone the interim injunction inquiry and keep the enjoining order pending, because here you have why should court hear a party with regard to his defense when he has no respect to court? And that is a position you can articulate. I would tell court, sir, why do you want to hear him on his objections when he's a man who has no respect to your honest court? First, he has to have dignity, to give dignity to your court. So these are things which you can, as an advocate as a counsel, by advocacy, try to take advantage of every action of a party. The counsel can take advantage of. So this is an instance where you can take advantage of, and courts will hear you on this.
Thank you, sir. I think we covered most of the areas that we wish to cover, because we have to allocate some time for the Q&A session. Also, we have received several questions in the chat box, as well as several people have messaged me on WhatsApp as well with regard to questions. I would invite participants to pose your queries to the chat box. It's convenient in that form. Before we move into the discussion, just to highlight several precedents that Mr. Mustafa, several precedents relating to matters that Mr. Mustafa explained to you with regard to the area of suppression and misrepresentation. I think the main judgments that one must be mindful of is the cases of Alfonso Appan versus Hettiarachchi, that is in 77 NLR 131. Then the Hotel Galaxy, the famous Hotel Galaxy case, Hotel Galaxy versus Mercantile Hotel Management, 1987 1 SLR 5. And the case of Walker and Sons versus Vijay Sen, which is in 1997 1 SLR 293. And also, I think uh, just to uh, just to highlight I think I did not when sir explained about section 666 of the Civil Procedure Code. I think there is one important judgment that you must consider. Which is a judgment that I have seen you quoting quite often in court. That is Ajit versus Ceylon Papers Act 2003 SLR 64. And with regard to the just tell me, sir, if I have missed any leading case that you think is relevant. And also I think another matter that you highlighted, which should be that one must be mindful of, is the fact that an enjoining order cannot be vacated ex parte. It has to, even though it is granted inter partes. Am I correct, sir, in saying that
Yeah,
the
party has
vacation
no
of an
benefit.
enjoining order must be considered as an inter partes inquiry? And that is laid out in the very famous case again called Finnegan vs. Galadari Hotels. This is in 1989 to SLR. And also with regard to the doctrine of, I think, comply and complain, the case of Cyril Gardiner, Regent International versus Cyril Gardiner, 1978, 1 SLR, 278. I think I think so. I have
You covered it.
covered the relevant precedents in those areas.
Yes, sir.
So just uh, I would first there is there is a question posed in our chat box. Uh, I think it's interesting question. Can you please elaborate on the difference between an injunction and a restraining order? I believe what the participant is asking is but the injunction and restraining order, but I think it's one and the same if I'm not
One and the
mistaken.
same except for a Mareva injunction or
Yes.
or a mandatory injunction. Mareva
Yes.
injunction is also a restraining order. Yeah. So I think end of the day, sorry, a mandatory injunction.
Yes.
Injunctions in terms of Judicate Act in the CP is in a restraining form, right? The mandatory form has developed through case law. So what he meant was a restraining order in terms of the CPC is an enjoining order and interim injunction.
So you basically, in terms of the Judicate Act and the Civil Procedure, because the Civil Procedure Code that says that you can get an injunction that is prescribed in the Judicate Act. Am I correct, sir?
That's right.
And so basically, you restrain or prohibit somebody from committing a particular act.
Yeah.
And also, sir, just to add to that, you mentioned about mandatory injunctions. So,
It's
am
a
I
mandatory.
right in saying that mandatory injunctions are permitted in certain
Yeah,
instances as an
mandatory
interim
injunctions
relief?
are part of our law, but court are hesitant to give say. If you see, except the road case where obstruction was removed,
Iris versus
right?
Pereira.
Yeah. So court are hesitant to do so, but mandatory injunctions have been recognized as part of our law.
So,
Even through
it's a
case law, Mareva injunction also, that's not mandatory, that's also a restraining form. But through case law, injunctive relief has developed. So
but
in terms of the CPs, it's only restraining orders, but then mandatory injunctions have been recognized because today, before you try to restrain a wall being built, right? The wall is built during the weekend. So what do? You come on Monday and say that you ask for a mandatory injunction, asking the wall to be broken. So court has if you can substand today, judges also have been very proactive. The judges won't take up the position. He couldn't have got you can't get a restraining order, right? In terms of all law, you can only get a restraining order in terms of that. I can't prevent a wrongdoer. So I would advise any client, right, to focus on the wrongdoer principle, even and you might be able to substantiate getting a mandatory injunction.
thank you, sir. Just but what I understand from what you said is that it's a very difficult threshold to pass to get a
It is a
mandatory
very
injunction.
because it's a substantive relief in full. But then again, a permanent injunction is all. But court are then to compel another person to do something. Court are more liberal when it's to restrain another from doing an act than giving a
Uh,
positive order to do or not to do something.
yes, and I have received several, in fact, messages on WhatsApp with regard to the Companies Act and how interim relief is obtained in the Companies Act. If you can briefly explain any particular differences that we must be mindful of, and how to go about seeking interim relief in terms of the Companies Act.
Companies Act is a sui generis procedure, and in addition to that, the benefit is if you get an interim order in terms of the Companies Act, it is operative until the other party moves to set aside. But then they have to file a petition. Till then, it's operative.
So basically, sir, what you mean to say is that the interim relief granted in terms of Section 521 of the Companies Act is you get an interim order until the final determination of the case, unless the respondent comes to court and asks for it to be vacated.
Yeah, but Mr. Kanagiswaran book, it has the same threshold as injunctions, except the fact the manner in which you vacate it and is operative until it's set aside, until you move to set it aside. So that's the only difference.
Yeah. So can you explain the normal procedure adopted if a respondent wants to get an interim order vacated in terms of the company?
You file a petition. In that petition, you ask for interim relief. Then the defendant wants to set it aside. He has to file a petition to vacate it. Then when he supports that application, the other party is entitled to file objection. So it is an inquiry within an inquiry. Unfortunately, so question is when you seek relief under the Companies Act, right? The petitioner gets relief. Then you want to vacate the interim relief, right? Then you file a petition. Then the plaintiff becomes a respondent. He files objections. So then that is also determined by written submissions or submission. So there's an inquiry within an inquiry. So sometimes, since it's a sui generis procedure under the company, it might be better to go ahead with the main inquiry and get it vacated. But anyway, in terms of the Companies Act, to vacate an interim order, it takes more time than vacating an enjoining order because it's operative until it's set aside. So you have to be very conscious of that fact. Now, if you are a commercial lawyer and you are in the commercial high court, right, and an order in terms of the company acted obtained against you, right, you want to vacate it. You file a petition to vacate it. You support it. Court is not going to vacate it because the act itself, the other party is entitled to be heard. He files objections. In terms of the CPC, there is no absolute right to file objections when you vacate an enjoining order. Here you have absolute right to file objections to when they move to set aside the interim order. So then it is fixed for inquiry. So then is inquiry within an inquiry. So you will have to take a judgment call in what you want to do. So if somebody asks me, how do you vacate an application in terms of the Companies Act, you file a petition to vacate it. Then the petitioner becomes a respondent, he files objections, and then he's fixed for inquiry. So there'll be two inquiries going. So if you file objections to the main inquiry, there'll be two inquiries going parallel. You and I could have faced that situation.
Yes, that is true. That is true. Just to add to certain other questions that have been asked, I think the Intellectual Property Act, unlike in the Companies Act, you follow the same procedure as the Civil Procedure Code, where you ask for
Intellectual Property Act has a specific provision that the CPC would apply. But I have a case where somebody went and got because interim measure, there is a particular word which is
interim measures of protection.
Interim measures of protection. Somebody has used that provision to get an interim order. But then court has only issued an enjoining order and notice of interim injunction. Now I am going to court and say there is no provision to get the interim measures. You can only get an enjoining order or interim order, because what it means is that the Civil Procedure Code has to be followed. So the other side counsel is saying in view of the fact that interim measures, he is entitled to get an interim order. But there's a clear provision which says that the civil procedure applies. If the civil procedure applies, you have to get an enjoining order or interim injunction. That is why in that case, the court issues notice of interim injunction and an enjoining order, even though he asked for an interim measure.
Yes, we have received another question from one of the participants with regard to the granting of interim relief against public officers. I think this is an aspect I think we can discuss somewhat, because I think there are certain instances where you can't get ex parte relief against parties. And also there is provision available under the constitution to get an injunction, which is closely aligned with the obtaining of injunctions against public officers and certain other public officials or entities, where injunctions cannot be obtained ex parte. If you can briefly
Anyway, your
explain that
law
also.
prohibits you from getting injunctions against a minister, right? But there are certain public authority. Now you can't get an enjoining order against the BOI. It has to be done ex parte. Then
Yes, the
there are
BOI
certain,
Act, I think, provides for,
and also the UDA.
states that an injunction can only be
UDA.
obtained with notice.
Yeah, if it's a local body, you have to give notice. But then there is provision for constitutional injunction where it specifically states where it's a public body or otherwise where there's requirement to give notice. You can go to the you can in the constitution there is a provision where there are constitutional which says where a particular notice is required in terms of the law to be given, and during that period you can go to the court of appeal and get that interim order injunction until that time period lapses.
So basically, if you want to get an injunctive relief against public officer, you have to give notice in terms of Section 461 of the Civil Procedure Code under normal circumstances. So if you are supporting an enjoining order or interim injunction against BOI, you have to give notice with regard to that application to the BOI. Which is the
and
UDA
then
Act also certain instances has that same provision, and
and then
the municipal
you go to
council's ordinance also. So what you mean to say is in those kind of
in
situations,
those
sometimes you
circumstances
can.
the law has specifically stated that you have to give certain notice, right? But where a minister, there is absolute prohibition of getting injunctions. So where you have a right to get an injunction against a public, you have to give the statutory notice, right? And then during that period you can go to the court of appeal and get an injunction for that period only.
But normally the Court of Appeal application must contain your draft pleadings and the demand you have
Yeah,
made to the public authority. Am I?
you need a draft plain and also the notice which you have sent. That is instances where you have right to obtain an injunction, but there is statutory notice to be given.
Correct. Uh, there is another question that we have received. I'm sorry, it's, really, this, I think several questions, several participants have asked. I think this is a confusion that has arisen because sometimes claims are filed where enjoining orders are not sought, but only an interim injunction has been sought. So the first part of my question is, can you move court only for only for interim injunction, where only notice, where in the first instance you only seek notice of interim injunction, or is it advisable to always ask for an enjoining order as well as a
There is no
formality?
mandatory requirement to ask for an enjoining order because the enjoining order is given until the interim injunction is concluded. So vice versa, you can't. There have seen claims which only ask for an enjoining order. And sometimes there are instances where people file petitions asking for enjoining orders and interim without asking, well, it doesn't correlate to the substantive. So the answer is you can ask for an interim injunction only. There is no bar, but you can't ask for an enjoining order only.
And also, I think, sir, you highlighted one point. I think he's set out in the case of it's also quite a well-known case, Mallika de Silva versus Gavin de Silva, that 1999 1 SLR 85, where it says that interim enjoining order can only be sought if an interim injunction has been sought.
That's right.
And also, I think that you highlighted another important point. If you can expand on that also, that the interim relief must correspond or correlate to the substantive relief. Can you explain that a bit more?
Yeah, but bottom line is the substantive relief is something which you're asking from court, and in the interim you're asking for this relief. So bottom line is to maintain that you have to show court that if I don't get this interim relief, now supposing somebody a permanent injunction, somebody is trying to break your wall, right? You're asking for a permanent relief, not to break the wall, right? In the interim you ask for an enjoining order and an interim injunction not to break the wall. So there is a correlation between the permanent relief and the interim relief. So always you can ask for substantive relief and then ask for interim relief, which is totally not correlated. There has to be a nexus to show that why I'm asking the interim. If you look at the Judicature Act as well, right? It is to protect the substantive relief in some form that interim relief is given. That is what 54.1 very clearly demonstrates.
Yes, thank you, sir. And also, just to add to that, I have seen in certain instances it is argued in court that if your permanent relief or if your substantive relief is only in a declaratory form, and interim relief can't be granted. But what is your view about that?
Yeah. Yeah. Earlier, that can be construed as contempt now with the new contempt law. As you know, a declaration of a status which cannot be enforced. So unless you ask for a permanent injunction, a declaration you can just frame it. There nothing flows from it. You can't enforce it. That means the question is whether there is contempt also is just a declaration of a status. So that is why when you draft a plan, you ask for a declaration. It's very important that you ask for a permanent injunction because that is enforceable. Now I have taken up I took up in a case I took up a position there only a declaration was sought in IP matter, right? I said that the enjoining order and interim injunction. I think plus you were with me in that case where
Yes,
they sought
yes.
a declaration, some pharmaceutical matter, where I said, look, they have asked only for a nullity, right? Right? Therefore, even if the substantive relief is given, I can infringe. Where they can't file, there's nothing which flows from that. So, a declaration of a status only, or declaration in some form, a declaration of a status. Therefore, nothing flows from that, and court has continuously held a writ cannot be executed against a declaration. Therefore, you have to ask for a permanent injunction in some form.
Also, I have got several questions. I think this is coming up in view of this area of specific performance, particularly uh, now. I believe the norm is that you can't specifically enforce something by way of interim relief. Am I correct in saying that, sir?
That's right. That's right.
And also I think just aligned with that, I think there is always this issue whether I think whether contract particularly for a service can you get some sort of interim relief with that? What is your view about that?
Our law has continuously held with regard to a contract service, you can't enforce it either way. The people are trying to enforce employee contracts, right? Contracts of service, you can't.
Yes. That is that famous case of Phoenix advertising
Phoenix.
was Abhegunathan,
That's
I
very
believe.
clear.
And,
Yeah, yeah.
and also just another thing, I think that this is something I think we must be very mindful of. Now you said in your earlier discussion with regard to the area of now for example in the case of Seelavati Mallava and the Karyosam Sujata Janaki, it has been clearly laid out that the wrongdoer can be restrained from benefiting
From
from
the
his
wrongful act.
unlawful possession in a ejectment suit,
Yeah.
especially if that wrongdoer is engaged in the conducting of a business. But I believe that does not mean in any form that by way of interim relief you can dispossess an individual.
You can't dispossess. I mean, that's why court very clearly said you can't dispossess, but you can't allow the wrongdoer. Ex facie, I can see that is a wrongdoer. Ex facie, he can be, you can't eject because the law doesn't permit one to do so. But I will prevent the defendant from taking benefits from the wrongful conduct by where he was running a business, preventing him from operating the business. So you say, be in here until the ejectment suit is decided, but I won't allow you to take benefit. That principle, I said, you can extend it in other areas as well. Don't, because it was a rent and ejectment case, don't think only in relation to a rent and go on the basis that the wrongdoer principle can take you places.
So just I think one final question, unless there are any other questions from participants. Now we spoke at length about the how to approach the interim injunction inquiry, the the conducting of the case up to the stage of the interim injunction inquiry. Any particular thing that now most interim injunction inquiries, in my experience, will not ultimately lead to a leave to appeal application. because one party will be dissatisfied with the outcome of the interim injunction inquiry. Any particular aspect that we must be mindful of when we are preferring an application either to the civil appellate high court when it comes to the district court or to the Supreme Court when it comes to the commercial high court, in a interim injunction matter? Oh, and also, is it a worthwhile exercise under certain circumstances to prefer an appeal to the appellate forum, or whether it is a worthwhile exercise to proceed to the trial if the interim injunction order is against you?
No, unless you can show that. But now, with regard to an enjoining order, I would advise a client never go to the civil appellate court, because court will say finish the interim injunction and come. Right? But with regard to an interim injunction, court also has to be conscious of the fact, am I to wait until the end of the trial? And therefore, I can demonstrate to court that on these grounds the interim injunction should not have been issued. So, I mean, end of the day, courts would also say, why don't you go and take it up at the trial and finish it off? That is the general thinking. But if you can substantiate your position and articulate your position very clearly that the interim injunction should not have been issued, it is worth giving a shot. But I feel in a lot of instances, right, you have to take a judgment call, because if there's a breach of prima fide, immediately you have a very good case to go. But then also prima facie case, if you can show that the plaintiff does not have then for the defendant, if the defendant has a prima facie case, for the defendant to take up the position of balance of convenience, does not lie, or irreparable loss, it might be difficult. So it's these are all very interconnected. You have to take a judgment call on the circumstance of each case. At the end of the day, if you go to the civil appellate court and you're not heard, and court within 5 minutes dismisses it, right? I mean, sometimes the client will think that you're not doing justice. So you have to be able to articulate yourself in the civil appellate court and put the required pressure to show that you have a case. But the worst thing for a counsel is go to a court and not get a hearing and say, why did you file this? You're wasting everybody's time, and it dismissed. So as much as facts and cases are important, right? You have to take a judgment call to protect your integrity. Because end of the day, clients don't know. Right? They look at it from a different perspective. So I'm being very candid. I mean, since this is for juniors, right? There is no point talking only about the law. We have to also tell them that how to take a judgment call, because it's a very tedious journey practicing. The first 10 years is very tough. So during that time, like, I'm very proud of you, plus what you have achieved. It's all depends on how you take decisions. And in original court work, you have to take decisions then and there. I mean, when you deal with the appellate forum, they know the law more than us sometimes. But original court, you have an opportunity of articulating yourself, because they are willing. They also want to learn. That's the truth. So you have to be able to, and also, especially if you are supporting an enjoining order, don't spend hours making submissions. Don't go and say, this is the plaintiff, this is the defendant, this is that. Judges get bored. Within 5 minutes, come to the point. Be articulate. First, come to the issue and then go to the parties. Because within 5 minutes, if you can't get the attention of the judge, after that it's difficult. So my advice is go to the issue where the judge is more interested in knowing the issue than knowing the parties or knowing anything else. So if you can show court that there is something to be looked into, court will take you seriously.
I think that is a very important word of wisdom from a seasoned practitioner, especially in the area of injunctions. Isuri, I think I don't have any further questions to Mr. Mustafa unless don't think if, unless there is any other questions. I don't think I can't see any further questions in our chat box also. Isuri, then are we at liberty to conclude this discussion?
Sure, Mr. Rupa Singh.
So before wrapping up, I would like to thank Mr. Mustafa for a very enlightening discussion. Made from a very practical perspective, I must say, as a junior, I think more than the law, I think law can be read from a book, but the practical aspects when it comes to advocacy and the law that a senior can impart upon us. I think that is the most important thing in these kind of discussions. And I'm thankful to the Bar Association, to Mr. Amrasuri and Mr. Galhena for spearheading the initiative of conducting these webinars. And thank you, Isuri, for cooperating with us. And I think I was a nuisance to you over the last few days trying to arrange this. But thank you, sir, and thank you, Isuri, and thank you for the Bar Association as well. Isuri, can I then wrap this up with your
Sure.
permission?
Thank Yes, thank you, Mr. Rupasinghe. This brings us to the end of the 12th webinar of the series on basics of law, titled Interim Injunctions. I thank our esteemed panelist, Mr. Faisal Mustafa, President's Counsel, and our moderator, Mr. Pulasti Rupasinghe, Attorney at Law, for the fruitful and educational discussion and for dedicating your time to be here with us and sharing your insights. I thank the BSL Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this insightful webinar. I also extend my thanks to all the participants who have joined in for the session today. Thank you, and I hope you all have a very